this evening. Julie's not feeling well, so you've got me and only me. The result of that is not only do you only have me, but I do not have any of the information that Julie typically brings with her. So if you're looking for phone numbers, websites, things like that, I'd ask that you email us so that we can provide that information, because usually Julie has a full folder full of information to pass things out for people, and I do not have that because she's not here. So I apologize in advance for that. I'll go over just very, very quickly what's been happening in the past month. I will say that I had wanted to move this meeting when the hearing on the settlement, which is tomorrow at 9:30, got moved. I would have wanted this meeting to happen after that, because I'm sure that many of you are going to have questions that arise as a result of that hearing. But quite frankly, the cost did not justify the move. So that's why I elected to just keep it on this evening, and we will probably have a shorter turnaround than 4 weeks for the next one, so that I can address some questions that you may have on that issue. To the extent that you have questions and I can answer them tonight, I will do so, however, knowing that we do not have a decision from the judge yet on what's going to be heard tomorrow. So I won't have any specifics with regard to the court's involvement or decision, but I can give you what my I'll call it, you may not, but my educated opinion will be as to what's going to happen tomorrow. Since we were last together, we have had mostly things happen in the litigation. As you know, as I just discussed, we filed a motion to approve a settlement, which we entered into with the Legacy St. Joe's entity, the Legacy Roger Williams entity, and Charter Care Community Board. So those are three of the defendants in both the state and the federal lawsuit, 3 of the 14, and they came to us almost immediately upon the filing and asked if we could arrange a settlement. We began discussing settlement with them in the late days of June, and it resulted in the settlement that we presented to the court, which originally was supposed to be heard on September 13th, I believe it was. In essence, without getting into the nitty-gritty of the settlement, in essence, St. Joe's, Roger Williams, and Charter Care Community Board have proposed to settle with us by giving us everything that they have. So everything that they have means both cash as well as whatever interests or claims those entities believe that they possess. And the reason why I put it that way, that they believe that they possess, is, as you have probably seen if you're following this at all, the Charter Care Foundation, the Prospect entities, as well as the Attorney General, have questioned whether or not, in fact, St. Joe's, Roger Williams, or Charter Care Community Board have some of the things that they have offered to give us in the settlement. If you are at the hearing tomorrow, what you will hear me telling to the judge when the judge asks me about the settlement is that the settlement is, I break it up into 2 piles. Cash, which would be immediately available, which is in the amount of approximately $11.5 million. It's actually a little bit more at this point, but that was what it was at the time that we negotiated the settlement. And then it is all of those assignments of interests and claims that they have. So those are the 2 piles of information, or the 2 piles of assets that we've negotiated. And what you will hear me say to the judge is that I would be recommending the settlement even if we only ended up with the cash. Put the rights of any one of those entities, St. Joe's, Roger Williams, and Charter Care Community Board, aside, the settlement makes sense for the recovery of approximately $11.5 to $12 million for the plan. Those rights that they are assigning to me as part of the settlement I'll consider it to be additional assets that I understand there may be a fight associated with asserting them, and it may result in additional cash, but I would be happy with the settlement even if it were just the cash portion. So my argument to the court is you need to approve it because it's in the best interest of this plan and therefore in the best interest of the participants, because it absolutely puts about $12 million into the plan, and then it gives us the ability to try to recover additional funds. Just like I was telling everybody during the investigatory phase of this, is just because we have a claim against somebody doesn't mean we actually assert it, because you do a cost-benefit analysis. What could we potentially recover from them versus what's it going to cost us to recover from them? If I say I can recover $200,000 from a party and it's going to cost us $200,000 to fight it to get it, then I'm probably not going to pursue that claim because it doesn't make financial sense. If I could recover $2 million and it's going to cost me $200,000, then I may look at it differently, because the net gain is much, much better, and it's worth the cost of $200 to walk away with a net of $1.8. The same holds true for the settlement. And the settlement in that way is I'm getting all of these rights and claims. Once I get them, I'll decide, along with special counsel, whether or not it's worth pursuing them. Some of them, the fight may be too difficult. The claim may be too protracted or tenuous. And so it may make sense for us to say, they gave us this right, but we're not going to pursue it because the argument isn't really strong in our favor, and it's going to cost way too much money to do it, and the resulting benefit to the estate won't be worth that cost. But there are others where we may actually dig our heels in and go right in and try to fight for it to grab some extra money in addition to the proceeds that we're getting. So that's essentially what the argument's going to be tomorrow. If you're there, you're going to hear from Charter Care Foundation. You're going to hear from the prospect entities. You're likely also going to hear from the Rhode Island Attorney General. And I believe those are the only ones that have actually responded to this settlement. Excuse me. And then we will have our counter arguments on that. Again, I don't know what the judge is going to do, but if I were, somebody asked me if I were going to put some money down and put a bet, I would bet that the judge is going to approve it. And the reason why I say that is because this is in essence a three-step process, and we are at step one. As a receivership, I'm entering into a settlement with 3 defendants. Before we can go to Judge Smith in federal court, who's handling the federal lawsuit, and say these 3 defendants want to settle the litigation with us and we need you to approve that, I need to get approval from Judge Stern, who is the court that appointed me and gives me my authority. I need his approval to go to Judge Smith in the first place. So Judge Stern's ruling should only be, I'm assuming, although he may go further, but the ruling is probably only going to be, I agree with the receiver that this settlement is in the best interest of the estate. Now go forward, and because of that, now you can go to Judge Smith, tell him I said that I thought it was in the best interest of the estate, and now he can review it under the guidelines that he has to review it for resolution of a class action suit. That would be step 2. And let's assume for the moment that Judge Smith approves it as well and says, I agree that this settlement is appropriate and I'm going to allow it to happen. Then we get the money, and then we would get into that analysis that I just spoke about with these other claims and decide whether or not we want to bring additional lawsuits to pursue those rights to try to recover more money for the plan. So that would be the step 3. So that's why I think tomorrow is not an easy decision, but I think in the grand scheme of the fact that this has more life that it has to go through before we get to a point where we can recover anything, I think Judge Stern would be most likely approving it on the basis that it is, in fact, in the best interest of the estate. I don't think anybody could doubt that the infusion of $12 million into the plan, nobody will be able to argue that that would hurt the estate. So it clearly is in the best interest of the estate, clearly is in the best interest of you as participants. And it would just be, does it make sense in the grand scheme of a class action suit in federal court? And that's step 2. So I think you'll see Judge Stern approve it tomorrow, but I do not know.
Can I ask a question? Does that include the money that's being held by those entities at the Department of Labor, or is that one of those side?
That's a more complicated question than it may sound, and I'll answer it as best as I can. So the cash portion, I'll call it, of the settlement includes all the money that those entities have, either in liquid cash and accounts or in investments that they can liquidate. In addition, there are escrows, I think that's what you're talking about, with the Department of Labor. There may actually be another one with another entity where St. Joe's had to escrow this money for workers' comp claims and other claims like that, where the state said, okay, you're shutting down your operations. There are these claims, some which have been brought, some which have not yet been brought yet, and we value them at, and I'm just going to use a round number, we value them at $2 million. So you have to put $2 million in escrow, pending either the expiration of any statute of limitations or the resolution of those claims. The settlement includes, because there's been an analysis done, at the time that the escrow was set up, there were, call it, 20 claims. Now there are 8. So we've had a discussion with the Department of Labor, and we've been able to put value that they agree with on those remaining claims, and they have been agreeable to release, as part of the settlement, a portion of those escrows, which will also make up the $11.5 million that we'd be receiving, which is why also, as those claims either expire or get reduced in terms of some type of resolution, there are additional monies as well that would ultimately be released, although we're getting the bulk of it now. It's less than $1 million that are going to be continued to held in reserve to cover those claims. But once those claims have gone through their life or their resolution, then we'll be getting the remainder of those funds as well. Okay. In addition to tomorrow, well, actually, let me back up a little bit. We have had a conference with both Judge Stern and Judge Smith, which was a joint conference with the 2 judges, which is not only something that's only happened once before, but it's a very unique circumstance for a case in general to have both the federal and the state court sitting and having a joint conference because of the joint administration that's necessary for the litigation. Not only is there litigation going forward in federal court and similar litigation in state court, which is currently stayed by agreement, but you have the receivership going on around both of those as well. So there are issues that become intertwined that both courts may need to weigh in on. And so what Judge Smith and Judge Stern have done, which I think it's only the second time that it's been done, this will be only the second time it's been done, is both judges have agreed basically to work together and, if appropriate, not only to conserve money, expense for doing it, but also to expedite the process. When possible and appropriate, they will sit together and hear hearings. So instead of saying, okay, we have to have a hearing in front of Judge Stern, and now we've got to go have a hearing in front of Judge Smith, and it's really the same exact thing, but you're in 2 different courts, so you have to argue them all over again. The judges have gotten together and said, we want to hear all of these at once. So we had that conference. It may not be, or don't be surprised, if you see the chief judge of the federal court sitting in the courtroom tomorrow, because he did indicate that he may be there, not only to observe so that he's aware of the issues that are being raised before Judge Stern, but also if something comes up where either one of them think that it would be appropriate for a joint hearing on the issue, there may be a brief recess, and they're going to confer, and it may result in Judge Smith putting his robe on right then and there and jumping on the bench, or them deferring a piece of it for another day so that they can hear it together. I will say I was pleased during the conference because one of the defendants argued that it does not make sense to address the settlement until the motions to dismiss and all related issues with that are heard. And the comment was made, and I'm paraphrasing, but the comment was made, what would be the big deal if we just waited till April or May to address the settlement? As you can imagine, or I hope you can imagine, I got upset with that and cut him off immediately and gave my 5 minutes of speech as to why that was an absolute terrible idea and why it would have a horrific effect on this case, on the psyche of each one of you, and everything else. And I'm happy to say that before the attorney could get even 3 words out to rebut my argument, Judge Smith and Judge Stern both told him that they did not need to hear anything further, that was not an option. So you, not only do you have me, but you've got both judges recognizing, as well as special counsel, the need to move this along, and that things like this settlement, they're going to have their own life, but we don't need to slow them down any more than they already will be through the process. So that conference concluded. It resulted in, like I said, a possibility that Judge Smith will be there tomorrow, and you may see that both judges scheduling hearings jointly where they will be sitting on the bench together, hearing arguments from counsel on issues that they believe impact both the receivership, the federal litigation, and possibly the state litigation. In addition to that, the only other thing that happened is that recently the prospect entities filed what's called a declaratory judgment action with the Attorney General's office, asking that the Attorney General weigh in on an interpretation of a limited liability company agreement that is part of our settlement, that we're saying we have the right to assert certain things. And this is my words, I think they tried to do an end around by doing this declaratory judgment action going to the Attorney General as opposed to addressing it with the Superior Court. In reaction to that, we have filed a motion to adjudge them in contempt. That is going to be heard on, I believe it's the 16th of October. What that basically means, for those of you who do not know, is when the judge appointed me in the order which appointed me as the receiver for the plan, he put a number of things in that order that were prohibited without getting permission from the court first. One of those things was you cannot take an action against the plan or any of its assets without getting court permission and without giving me an opportunity to weigh in on it. And if you do, then you're in violation of the court order, and the court can adjudge you in contempt. I have taken the position in the contempt that the declaratory judgment action is attacking the settlement, and that the settlement is a contract that I signed, and therefore once I signed it, it became an asset of the plan. Subject to the judge's approval, but until the judge says no, it's an asset of the plan. So by knowing that I signed the contract for the settlement, knowing that I'm seeking approval, and after that going to the Attorney General without first going to the judge and saying this is what we want to do, we want authorization to do it, that they are in contempt of the court's orders. So for both reasons related to the amount of time that we have to give them notice of these things, as well as because we did not want to distract away from the settlement itself tomorrow, that was scheduled out for the 16th, which is next week. So that's what I'm doing. The contempt could, to the extent that any of you have a question as to what that may mean if the judge rules that they are in fact in contempt, it could result in anything from a warning to them or an admonition or telling them that they cannot go forward with that declaratory judgment, to a financial penalty, to any combination of that. So it's unclear as to how the court will if the court finds contempt, it's unclear what the court would award in terms of damages to us for that contempt. It's unclear as to whether or not the judge will even grant the motion to adjudge them in contempt, but that's what's pending. I guess the long and the short of it is that the litigation and the battle on all of this, the settlement, this is not, I'm surprised by some of the parties who are objecting, but I'm not surprised that there are objections. But we are doing everything we can not only to get the settlement approved, but to hold all of the defendants accountable and make sure they're doing things the right way. For those of you who were at the court recently on the issue with the interpleader, where we're trying to get involved in the Cypre action, where the judge actually approved it, you heard all of the arguments of Charter Care Foundation as to why we shouldn't be allowed to do it, this and that, and at the end of the day, the judge said, you haven't proven that they don't have a right to be there, and they can argue whatever they want to argue, and we'll deal with the merits of it, but they at least have a right to raise the arguments. Obviously, the court, special counsel, are not going to do anything improper, but there is always an eye in this case towards, this is not just a legal issue. I'm a lawyer, judge is a judge, but this is affecting your lives, and that is ever present in everything that we talk about. The argument that I made to rebut the attorney who suggested that this can wait till April or May, I can tell you I didn't cite one rule of law or case. My argument was completely practical and based on the impact on the plan and ultimately upon you, because that was actually the most important thing to discuss with that issue. It wasn't a legal issue per se, it was a practical and fairness issue. And fortunately, both judges concurred with my opinion on that. With that, I think that brings everybody up to date with where we are heading into tomorrow. And as I typically do, I will open it up for any questions.
The three St. Joe's graduates in Charter Care, the three of them together, what you got, the 11.1 from the three of them.
That's correct.
So what happens with the St. Joe's that didn't put in for 10 years there? Are they going to be able to recoup the money that they didn't put in for 10 years, or that's just...
Unfortunately, like I said at the outset, is our settlement with them is really basically give us everything you have. So once they give us the money, assign the rights, transfer the interests, all of those things, they will have absolutely nothing left to give. So that's whatever we can squeeze out, we're squeezing out, and they will continue to be shells. They will have to go through a dissolution process, but they'll be shells that have not even $1 to their name, because we're not going to leave them with anything. I know. Yes. So the answer to the question was, is there any update on the PBGC issue? Simple answer to that question is no. We have had minimal contact with the PBGC. We are making sure that we provide them with copies of every pleading that's filed, whether it be in state court or federal court, because we're sending it actually to the PBGC, to the IRS, and the Department of Labor. Because we do not want anybody at any time saying, well, we didn't know what you were doing. So we are sending directly to our contacts there. Beyond those communications, there has been nothing. Jeff Cohen, who you just mentioned, is an attorney who I have engaged to assist me on the PBGC ERISA-related issues. Jeff is a veteran attorney who, and I don't hold me on this number of years. It may be more than this, but I believe he spent 18 years as general counsel to the PBGC. I think he was there as late as 2007, 2008 was when he was last there. And so obviously he's got some substantial insight into that department. He also still has relationships existing in the PBGC. I will say it does not surprise me that we have not heard anything from the PBGC, because our last communication with them was until you get a determination from either the IRS or the Department of Labor, we're going to treat this as a church plan, because that's what it's always been considered by the people who are running it. So they're basically saying, we've looked at everything. Everything we've looked at says that this was treated like a church plan, and so we don't have any reason to doubt that, and until the IRS or Department of Labor tells us differently, we're going to treat it that way. That doesn't mean that we're going to accept that. Obviously, in the federal litigation, we've asserted that this has not been a church plan for a very long time. There are parties as well who have, some of the defendants have said, well, you've raised these issues with ERISA and the PBGC, and so you need to bring them into the case. They're necessary to be here, and if you don't do it, then the case can't go forward. We don't really think that's the case. Those issues will kind of work themselves out through the ordinary process. If we have to join them, we will, but we don't think it's necessary at this point. Pension Benefit Guaranty Corporation. So they are a federal agency that insures ERISA pensions, of which a church plan is an exception to ERISA and not covered.
A couple of questions, to the extent you can answer them, and some observations. The settlement with Childcare, St. Joe's, and so on, to the extent you can comment on it, was the basis of liability the misrepresentation of the funding, of the fact that they did not fund it properly? I assume it was the former.
It was, although there is no admission of liability in the settlement, they did come forward and say that the plan is deficient by approximately $120 million, and they're acknowledging that their efforts, or lack thereof, contributed to that. But there is no designation as to how those efforts contributed to that.
We're proceeding against Prospect Medical. Their basis, they had nothing to do with the funding previously, but they were instrumental in representing the fund as being adequately funded. So my question is, to what extent, to what monetary exposure may they have going forward? In other words, if we're looking toward some major settlement in the future, realistically, where does that lie?
As far as I'm concerned, I know what Prospect's arguments are. They've raised them both orally in conferences and discussions. They also asserted some level of those arguments in their motion to dismiss the federal lawsuit. Quite frankly, I'm not persuaded by them. And as far as I'm concerned, each defendant should be responsible for the entire amount. It's whether or not Prospect had a hand, 10%, 20%, 30%, 40%, that's up for the court or a jury to decide. But if we're talking about if Prospect were to call me up and say, how much money do you want in order to let us out of this case? My answer to them would be $120 million. Assuming, of course, that the settlement isn't reached at that point with St. Joe's Roger Williams. If it is, then I'll reduce it by whatever I get from them. But ultimately, this plan needs a certain amount of money to live so that each one of you can continue to receive your benefits at a level of 100% for the rest of your lives. And whatever that dollar amount is the dollar amount that I want, whether it's from one or all, I don't care. I just want to make sure that the plan gets as much as it can, and Prospect can argue that their liability is limited to a certain percentage, and obviously we'll be arguing that that liability goes well beyond what they're arguing. Does that answer the question?
To some degree, also the diocese and bishop who were involved in the process, again, not responsible for funding, but were obviously aware of what was going on both before and after the sale of the system.
Well, I'll say that, obviously it's pending litigation, so I can't get too deep into the weeds. But there's a big difference in terms of when you're talking about the responsibility as to who was responsible to fund versus who wasn't responsible to fund. But what we have in this case is you peel back a layer, because there's who knew what and when, and what were they supposed to disclose and to whom, whether it be to you, whether it be to the Attorney General, whether it be to Judge Stern when he was overseeing the conversion application, for example, the Cypre. So whether or not, for example, and this is hypothetical to the extent that any of the defendants are watching, this is hypothetical, that to the extent that, let's say, Party A had no obligation to fund the plan, but yet when seeking to have the transaction approved, they made representations that the plan was going to be fine and that X number of dollars would be injected into it, and that that money would be sufficient to make it live for the rest of its life as it needed to provide for each one of the participants. Once you start making those representations and you get your transaction approved on the back of those representations, which ends up being fraudulent, I don't care if you had an obligation to fund it on day one, you were making representations that it would be funded down the road. So you basically adopted the obligation for yourself by way of your fraud. That's a very simple way of, certainly the arguments to the judge will be a little bit more eloquent and detailed than that, but that's in essence what the argument is you bought it. When you went in to try to sell your sale of this hospital, and you made representations that you knew or should have known were not true, and made representations to each one of you, you bought this obligation whether you thought you were or not.
That's reassuring. I think it's reason for some optimism, although I think this is going to take a number of years before we fully realize the maximum benefits. Is there any insurance that is responding, for example, the child care Roger Williams? I know is a type of coverage put a flying. I'm not sure if it excludes anything to do with pensions. But has any insurance responded either on the defendants who are close to settlement or any of the other defendants who are still pending?
Do you mean like some type of like director and officer insurance or something? There is. I would be shocked if all of the defendants that have any type of what's called D&O policy, director and officer policy, didn't put their carriers on notice. And I do know that part of the money that's being funded or being proposed in the settlement that we have will include a portion that is being kicked in by the insurer for directors and officers. Of course, for example, we've argued, although briefly because we haven't gotten into the merits of it, that Charter Care Foundation, for example, shouldn't have actually even existed. They didn't actually go through the proper procedures. So we would actually argue, and I think the insurance company would jump right behind us and say, yes, we agree, that they shouldn't have D&O coverage because they actually aren't officers. They shouldn't even exist. So how can you have D&O coverage to cover the acts of directors and officers that actually aren't legally properly in place? So some of our arguments may actually exclude that from those entities.
Has the new actuarial study been completed yet?
No, it has not. And that was actually something that I can say it was personally frustrating to me because I was under the impression, based on email communications that I had with the prior actuary, that certain things were being done and in process, and that when we moved over to GRS, that if it weren't completed, that they would just have to take it over the goal line. And I found out just maybe about 2 weeks ago that that was actually not the case, that they actually hadn't started any of it. So I immediately engaged GRS to immediately start putting that together, and they have already started putting it together. They advised me that it should be done within the next 30 days, which that was about a week and a half, 2 weeks ago. So I'm expecting something within the next 2 to 3 weeks from them, which would be evaluation. We're also having a full audit done on the plan by Caliber Group, which, if you've read my reports, they've been mentioned in the reports as well. So that's an accounting firm out of Washington, D.C., that actually specializes in financially distressed plans, and in particular, financially distressed church plans. And they are doing the audit for us as well on that, so which has not been done. There was actually no accountant in place that I was aware of that was actually conducting the audit, so this will be the first one that's done.
Okay, thank you. That was on behalf. I didn't really think we were still collecting a full pension guys at this stage.
I'm not going to. I'm always optimistic, but I'm a pessimistic optimist, and so I had hoped that we would be here today still talking about things with everybody still receiving their benefits. I had my questions once the switch got turned back with the ones that had been kind of held in limbo after my appointment. But I'm happy to say that we've been able to do it, and that actually the erosion of the plan's assets is much, much less than what we had anticipated would be the case. So we've got partially the market to thank, and partially you to thank, because there could have been panic mode from all of the participants and caused some major financial problems for the plan, and we have not run into that right now. And one thing that would greatly assist in making sure that this trend of benefits continuing at their current level, which is 100%, for a good portion into the future, is to get an infusion of about $12 million into the plan, which I also think will encourage other defendants to step up. Nobody wants to be the last defendant in a lawsuit. So settlement with one or two or three usually opens the eyes of the others and says, let's sit down and sharpen our pencil and see if we can get something done as well. And I will tell you, although I can't give details, we have been approached by other defendants as well to discuss possible settlement. And those are in their early stages. But what I had hoped would happen with the settlement with St. Joe's, Roger Williams, and Charter Care Board has happened, in that it's encouraged other parties to come forward and say, okay, we need to do this now as well, and at least test those waters. Any other questions? As of right now, you stand exactly as you should be, which is with a plan that is paying out benefits to all eligible participants who have elected to start receiving, and they're receiving 100%. And my goal is to have the plan there and funded so that you, when you reach your eligibility period, can make that same decision for yourself. Whether or not that's the case, this lawsuit and issues with the PBGC and all of that, it remains to be seen. The market could affect things, settlements, the PBGC coming in, or a determination being made that they should come in. All of those things will impact it, but as of right now, As long as those that are receiving benefits are continuing to do it, then you're heading down the same path that you expected to be heading down at this point. Not at this point, actually before this point. Any other questions? Before I would have appreciated doing this meeting maybe tomorrow night or the night after, but just financially it didn't make sense to do it. So like I said, I will have a quicker turnaround for the next meeting. I don't think I'm going to wait 4 weeks. We may do 2.5 to 3 weeks from now. Obviously, if you have any questions after tomorrow's hearing, you can shoot me an email. And if there's anything that is of note, I will put a notification on the website to explain to everybody what happened or didn't happen. And then one last thing is, to the extent that this anybody appreciates it, the pastor, is he the pastor? The pastor of St. Rose and Clements, Father Matt Glover, apparently published, it looks like maybe kind of an opinion of his position in the church bulletin. Was it last week, Marilyn? 3 weeks ago. And he expressed his support. I will read, Marilyn was kind enough to highlight for me some of the comments that may be impactful upon you, and I will say that I appreciate, as I'm sure you do, the support from anybody in the public and the community that is in support of what I am trying to do to try to help you keep what you worked very hard to earn for yourselves. But he says, what about all the dedicated nurses who have lost out on 60% of their pensions in the recent sale of St. Joseph's Hospital? And then he goes on to say, in my opinion, this inequity in pension funds is an example of clericalism, which is the notion that priests are somehow more superior than lay people because of their calling. Therefore, they should be taken care of at the expense of the laity. I reject this notion of clericalism wholeheartedly because priests are not superior to the laity in any way. We are all baptized into Christ Jesus, and that is where our dignity as God's children comes from. In good conscience, I cannot ask for money for my pension when I know so many others who have also dedicated their entire lives to God in His service as teachers and nurses will not be justly compensated. Why don't we start a second collection for them? Maybe then God would be glorified in, all caps, all things. And that's signed Father Matt, which is Father Matt Glover. So I know that I can tell you that you have a lot of support in the community. I'm sure that you speak to those in the community. And unfortunately, not many from the clergy have stepped forward, but Father Matt has. He's not the only one, but I commend him on his courage to publish something like this in the bulletin and for his vision of what's right and what's equitable. And with that, with no questions, I wish you all a very good night on this summery October evening. And I will see you, if I don't see you tomorrow, I will see you in a few weeks. Thank you, everybody.